Manong Fred, with your indulgence, pwede bang, hindi mo naman kailangan ng mic, pwede ba patanggal na natin yan? Nadidelay yung proceedings eh.
Mr.
Okay,
Chairman,
so,
are we...
okay,
Di ba?
sige.
Na-record ba yung sinabi niya kanina? Pakiulit mo dahil hindi daw na-record.
Without mic, without mic. Anyway, this proceeding is now resumed.
May ask, were the statements of the gentleman recorded? Na-record niyo naman?
Please answer. Meron ba? Recorded, duly recorded?
Okay, thank you.
Okay. Sige, so we now recognize...
Mr. Chair,
we will not entertain the motion because there is a pending
Okay,
motion.
thank you. That was what I needed from the chair.
Yeah. So we now recognize Congressman Lagman.
Thank you, Mr. Chairman. I am objecting to the presentation and motion of the distinguished Representative Roque for the following reasons. Number one, the substitute verification has no legal basis in the rules of procedure for impeachment cases of the House. There is no specific rule granting any party the right to amend the verification or the complaint for that matter. It is flawed to take the position that just because the pleading or amendment is not allowed, is not prohibited, it must be allowed. Number two, since the paras to pass your complaint has been referred to the Committee on Justice of the House, any determination with respect to form must be based on the original verification submitted by the complainants. Number three, the attempt to make a substitute verification is a clear admission that the original verification is fatally defective. Number four, the motion to admit substitute verification is not even filed with leave of the House Committee on Justice. In fact, it is addressed to the House of Representatives, and the House of Representatives in plenary has not acted on the substitute amendment. Since it is addressed to the House, then the House must take action on it, and if it wants, it could refer the substitute amendment to the Committee on Justice. It has not done. So legally and technically, the substitute verification is not with this committee. Next, Mr. Chairman, the amended verification was submitted alone. It was not attached to any complaint. And the amendment of the verification is a virtual amendment of the complaint, which was not submitted by the complainants. Next, it is required, Mr. Chairman, that any amendment, there should be a submission of the amendment, including the complaint, and highlight the amendment thereto. Next, if we entertain this substitute verification, which is virtually an amendment to the complaint, we will be we will not be observing the one-year rule ban, because this committee has already jurisdiction with respect to the referral of the Topacio Paras complaint, and the ban has already started. An amended complaint and an amended verification will violate that one-year ban. For all of these reasons, Mr. Chairman, I am objecting to the position and motion of the distinguished Roque.
Thank you, Congressman Lagman. We now hear the objection of Congressman Uwaminad.
Good morning, Mr. Chair. This humble representation is objecting to the motion because of the following grounds. First, in the case of Alejandro versus the President, it is this humble representation, Mr. Chair. This humble representation is objecting to the motion because of the following grounds. First, in the case of Alejandro versus the President, it is this humble representation that moved for the sufficiency in form, but it was faced with so many objections from the members of this House. I was arguing to set aside technicality in furtherance to substantial justice, which in the final round, after I asked for an executive session, my motion was carried with the clear amendment introduced by the Honorable Majority Leader, the Honorable Farinhas, that should be the last action of the committee to consider liberality. In the case of Jimenez against Chief Justice Sereno, when I read the verification to have also the same defect with that of the Alejandro case, I was the one who first raised the issue that in our previous decision, we had already agreed to set aside liberality and to set up this standard of procedure in the determination as to the sufficiency in form for the future impeachment proceedings. So that allowing the amendment of the verification is in effect allowing liberality, which will now run counter to the standard procedure that we had agreed. Secondly, it is my position that amending the verification is a substantial amendment because it will affect the substantial right of the respondent. And then, being a substantial amendment, therefore, will be in violation of the one-year bar rule, as cited in the case of Gutierrez. The one-year bar rule shall apply once the impeachment will be referred already to the Committee on Justice. And this case was referred to us on September 7, and the amendment was filed on September 13. While it is true that in the proposed amendment, it was addressed, it was in the heading of the House of Representatives, but it is not filed before the House of Representatives. That's why it is not taken by the plenary, because it is filed directly to this Committee on Justice, which is, it is my position that the motion is improperly filed before this committee. And with that, Mr. Chair and my distinguished colleagues, I am objecting on the allowing of the motion of the Honorable Roque to amend the verification.
Thank you, Vice Chair Omnal. We now recognize Congressman Salo for his objection.
Thank you very much, Mr. Chair. At the outset, I'm one with the complainants and the endorsers in seeking the truth, in knowing the truth, in digging the truth. I respectfully submit, however, that the search for the truth cannot be made at the expense of other equally important and fundamental values, principles, and policies that our society uphold and from which our democracy is anchored. This cannot be done and should not be done. I respectfully note that the motion on the proposed amendment of verification is creatively presented as it has the same effect, objective or effect of ensuring that the complaint shall be admitted despite its obvious defect. By allowing it to be cured, preempts and changes the inevitable effect, the dismissal of the complaint. As such, the motion is inextricably linked with the discussion on the complaint's insufficiency in form. Mr. Chair, this is not a mere substance, form, or substantial technical dichotomy issue, or something of transcendental importance. This is an issue that goes to the very core or the foundations of our democracy. First, this is about laws and rules. We have just hosted the ASEAN Interparliamentary Assembly, and we wanted everyone to know that in this part of the world, we are governed by laws and rules and not the whims and caprices of men. That laws and rules are primordial even if these go against our personal desires, and our actions and decisions should be undertaken based on set rules. And while laws or rules may be changed, they cannot be changed at the middle of the game to accommodate certain complaints. Second is about fairness. We should use the same yardstick that we use in scrutinizing the impeachment complaint against the Chief Justice with the current complaint. We cannot treat the current complaint differently with the VACC complaint against the Chief Justice, which we have just dismissed, as there exists no substantial difference between the two. To do otherwise would be unfair and unjust, not just to the parties but to all our countrymen. And third, this is about consistency and predictability of results. As I oftentimes joke in my class, this is the paradox with the civil law countries such as the Philippines and common law countries such as England. In civil law countries, everything is written. And yet, even if these are already written, you don't usually get the same results, even in similar cases, as lawyers would always have a way of justifying your actions or failures. Yet, in common law countries, even with an unwritten constitution or law, you get consistent and predictable results. No wonder most common law countries are the preferred legal systems among private parties. But perhaps this is a usual challenge faced by young democracies, such as the Philippines. However, our legal system needs to grow and mature and to respect and apply laws and rules as they are written. Certainly, the verification form is not very difficult to follow or to comply with, Mr. Chair, particularly among lawyers who are presumably learned or trained in the practice of law. And the failure to comply with the required form should merit the expected consequence, the dismissal of the complaint for being insufficient form. Thank you very much, Mr. Chair.
Thank you, Congressman Salo. We now recognize Vice Chairman Doyle Leachon.
Good morning, Mr. Chair, and of course to our dear members, so with our visitors at the hearing on this Committee of Justice. Actually, Mr. Chair, going to this hall, to my mind, I have more or less concluded that this committee, so with the Filipino people, have been seeing a continuing phenomenon on how the Constitution would work. And really, the Constitution has been operative in this country and has been provided or has been providing a very clear concept of democracy. Why? Because for the past months that I have been your vice chair, I have seen the continuing phenomenon. Why? Because in the Constitution, there are more or less about 7 agencies or officers who are impeachable. But in about less than 6 months, this committee, more or less out of liberality, has accommodated more or less about 3 impeachment cases. One against the president, which we dismissed. The second was against the Chief Justice. The first complaint was accommodated. The second one was dismissed. And now, another constitutional body is being questioned, and is in being threatened to be removed from office, of course, on various grounds. Now, going to the meat of the issue, the Congress, under the Constitution, definitely has to play its role as a defender and it's operating as a politico-legal mechanism because Congress, by virtue of impeachment, is definitely tasked primarily as the protector of the people, as a body politic. Of course, we have our good friends here, our illustrious members of the Congress, and of course, reading the grounds. But in answer to the motion of our good friend, Congressman Harry Roque, that the motion to admit the supplemental verification be admitted, I have these 2 cents worth to say. Number one, not actually just very recent, about a week ago, we decided the case of the impeachment case against Chief Justice Sereno. And the second case was dismissed, which was filed by Dante Jimenez of the VACC. And it's very clear. When I read yesterday and when I asked for the copy of the impeachment complaint against Chairman Bautista, undoubtedly, it's a perfect, wholly excellent copy of the verification of the Sereno case, which we dismissed. In fact, we dismissed it with prejudice. Going to the meat of the issue right now, as again, I would like to say that if we will deviate from the previous ruling, definitely this Congress will be criticized not only by the members but by the people. The whole Filipino nation is looking at us. We had our decision a week ago, and to deviate from the previous ruling is actually out of order, Mr. Chair. Finally, it was said that the admission should be admitted out of liberality because in various Supreme Court cases, the Supreme Court has held that it should be, as a matter of procedure, be dispensed with in lieu of the substantive requirement. But then, Mr. Chair, I have 2 grounds. Number one, the issue of impeachment is provided for very clearly to be under the exclusive jurisdiction of the House or of Congress as an institution. Therefore, all procedures should be within the realm and jurisdiction, power, and authority of the House of Congress and not before any courts of justice, unless the acts or actuations of Congress would be ultra vires. Considering therefore, Mr. Chair, considering the premises, because of consistency and of course to conform with the uniform procedure that this committee has implemented and for future purposes so that a similar complaints or similarly situated may not be entertained, with due respect to Congressman Roque and our good friends endorsers, I would like to vote for the objection to the motion. Thank you, Mr. Chair.
Congressman Leachon, we now recognize Congressman Fortun, and after that, Congressman Gonzaga and the Majority Leader.
Thank you, Mr. Chairman. Just very briefly, Mr. Chairman, let me just emphasize, Mr. Chairman, that the verification is not an ordinary formal requirement. It is an indispensable requirement in impeachment complaints, the absence of which kills the complaint itself. Because while we call it a formal requirement, Mr. Chairman, I would like to posit the view that it is not a mere formal requirement because the verification goes into the very substance of the complaint itself. Because the verification contains the attestation and confirmation by the complainant himself, or themselves for that matter, of the existence of documents, of the existence of authentic documents, and of the truthfulness of the allegations therein, according to his or their personal knowledge, Mr. Chairman. That is why the Supreme Court, in many cases, has consistently decided that an unverified complaint or a complaint that has defective verification is treated as an unsigned pleading. And an unsigned pleading has no legal effect whatsoever, Mr. Chairman. So on that basis, Mr. Chairman, especially so that this is not an ordinary complaint before regular courts, but a complaint against officials of a democratic institution, I suppose, Mr. Chairman, I think that with due respect to the Honorable Harry Roque, his motion must fail, Mr. Chairman.
Thank you, Kong Fortun. Kong Gonzaga, you now have the floor.
Thank you, Mr. Chair. While is it true that the rules on impeachment does not contain provision as to the regard to the amendment or the acceptance of the amendment of any defect in the complaint, it is also true that when the majority floor leader introduced the sort of an amendment to the procedure when we decided the case of Alejano versus President Duterte, somehow that liberality thing was a thing of the past. The decision of the committee in the Alejano case and the introduction of the no more liberality in the next procedure, impeachment procedure, that is tantamount to an amendment of the rules of procedure. It becomes our jurisprudence. It becomes part of the rule in Congress. Because it is an amendment to the rules of procedure, therefore, it becomes, we are bound to it. So, bumoto ako noon, bumoto tayong lahat, and with due respect to Harry Roque, he voted in favor of the introduction of non-liberality. Because we voted, we are then bound by it. So, nagiging part na yon sa rules of procedure natin. So, I think the move of Harry Roque must fail based on that ground.